He privately planned to give the Prime Minister a brief taste of custody, simply for disagreeing with him. But when High Court Judge Sir Reginald Thornton publicly declared Keir Starmer in contempt of court, the nation didn't see judicial authority upheld. They witnessed power dangerously misused. The judge thought he was silencing a politician who dared challenge the bench. Instead, he ignited a constitutional firestorm, inadvertently forged his adversary into a national hero, and exposed the raw nerve where justice meets the people's will. Britain watched, breathless, as the establishment began to crack. London buzzed like a disturbed hive the morning the story broke. It began not with a leak or a scandal, but with a stark headline halfway down the front page of the Times, austere and chilling: High Court Judge summons Prime Minister for contempt hearing. Within hours, the arcane legal threat had detonated across every news channel, every app, every corner of the political sphere. Prime Minister Keir Starmer ordered to appear before the King's Bench Division. The charge, initiated by Mr. Justice Thornton, Sir Reginald Thornton, a sharp-featured judge appointed years prior, known for his traditionalist views and barely concealed disdain for politicians, was scandalizing the court, a rarely used form of contempt. The accusation stemmed from remarks Starmer had made 2 weeks earlier during a visit to Teesside. Standing beside anxious local leaders, he had publicly criticized a High Court injunction, issued by Thornton himself, which had abruptly frozen government funding for a crucial regional development project, a new advanced manufacturing hub promising hundreds of jobs in an area scarred by decades of industrial decline. When judicial decisions, Starmer had stated, his voice tight with controlled anger, however well-intentioned, risk strangling hope in communities the system has too often ignored, those decisions must face scrutiny in the full light of day. That sentence, measured but pointed, had ignited a firestorm in legal circles. Judge Thornton, interpreting it as a direct attack on his authority and the integrity of the court, had made his move. A sitting Prime Minister, threatened with contempt proceedings for defending government policy and the communities it aimed to serve. Reporters swarmed Downing Street. Pundits struggled for precedent. A constitutional crisis in the making, declared the lead BBC political correspondent gravely. Uncharted territory, echoed Sky News. Yet Keir Starmer didn't issue furious denials. He didn't brief friendly journalists. He didn't appear on television. Number 10 released a single terse statement. The Prime Minister respects the judiciary, but will robustly defend the right of elected ministers to comment fairly on matters of significant public interest. He will attend the hearing. The quiet defiance was almost more shocking than an outburst. The stage was set for an unprecedented confrontation between executive power and judicial authority. The scene outside the Royal Courts of Justice on the Strand was unlike anything London had witnessed in decades. It wasn't the usual noisy political protest, but a silent, almost reverent gathering. Hundreds, then thousands, had travelled overnight, not bussed in by unions or parties, but ordinary people carrying handmade signs. Steelworkers from Redcar stood shoulder to shoulder with fishermen from Grimsby, former miners from the Welsh valleys next to nurses from the Midlands, community leaders from towns whose names rarely graced the London papers. They didn't chant slogans. They simply stood, a quiet testament to the communities Starmer had defended. Inside, Court 4, the Lord Chief Justice's court, was packed. Not with the usual array of barristers and clerks, but with these same faces, people who had likely never set foot in this imposing building before. They filled the public gallery, their presence a silent rebuke to the perceived remoteness of the proceedings. Keir Starmer entered, flanked only by his principal private secretary, eschewing the phalanx of lawyers typically surrounding a leader in crisis. He had made a controversial decision. He would represent himself. If this is about my words, he'd told his astonished cabinet the previous evening, then the court should hear them directly from me, unmediated. He took his place at the solitary table facing the bench. Sir Reginald Thornton entered, robes flowing, his face an impassive mask, though his eyes held a glint of cold severity. He banged the gavel once. "Let the record show," the clerk intoned, "that the Prime Minister, Sir Keir Starmer, appears in person and without counsel." Thornton adjusted his spectacles, his gaze fixing on Starmer. He wasted no time on preamble. "Sir Keir," he began, his voice crisp, cutting through the silence, "did you, or did you not, state in a public address in Teesside on the 14th of May that judicial decisions risk strangling hope and must face scrutiny in the full light of day. The precise quote hung in the air. Starmer leaned towards the microphone. "I did, my lord," he replied calmly. Gasps rippled through the gallery. Thornton leaned forward. "And you understand, Prime Minister, that such language, directed at a ruling of this High Court, could be construed as calculated to undermine public confidence in the administration of justice? That it borders on contempt?" Starmer met his gaze directly. "My lord," he began, his voice measured but firm, "I understand the gravity of these proceedings, but I also understand the gravity of that injunction on the lives of thousands of people in Teesside." The battle had begun. Sir Reginald Thornton's expression tightened at Starmer's response. "This court is not concerned with the political consequences of its rulings, Prime Minister," the judge stated icily. "It is concerned with the rule of law, which requires respect for judicial decisions, even those one disagrees with. Your words appeared calculated to incite public hostility towards a lawful judgment." Keir Starmer stood his ground, calm but resolute. "My lord, my words were calculated to highlight the real-world impact of that judgment on communities who have been promised investment, promised opportunity, promised hope. My duty as Prime Minister is not just to respect the law, but also to speak for those communities, especially when decisions made here," he gestured around the imposing courtroom, "have such profound consequences there." Thornton scoffed audibly. "Are you suggesting, Sir Keir, that your political mandate allows you to disregard or undermine judicial authority whenever it proves inconvenient?" The accusation hung heavy. Starmer didn't flinch. "No, my lord," he replied, his voice steady. "I am suggesting that the judiciary, like Parliament, like the government, ultimately serves the people of this country, and when a judicial decision inflicts demonstrable hardship, particularly on those already disadvantaged, it is not contemptuous to point that out. It is my democratic responsibility." The energy in the courtroom shifted. The quiet attentiveness of the public gallery sharpened into focused intensity. They recognized the core of the argument, the perennial tension between unelected power and democratic accountability. Thornton leaned forward again, his voice dropping, laced with menace. "Do you consider yourself above the law, Prime Minister?" Starmer met his gaze, a beat of silence. Then the reply that would ricochet across the nation. "No, my lord, but unlike some, perhaps, I do not consider myself above the people the law is meant to serve." A collective intake of breath. Reporters scribbled furiously. The judge's face flushed crimson. This wasn't just legal argument, it was a direct challenge to the judge's own perceived detachment. Judge Thornton slammed his hand down on the bench, the sharp crack echoing through the courtroom. "This is not a political rally, Sir Keir," he snapped, his composure finally breaking. "This is a court of law. Your populist rhetoric has no place here." Keir Starmer remained standing, unshaken. "And yet, my lord," he countered, his voice still calm but carrying undeniable force, "the people filling your public gallery today, the people whose lives were directly impacted by your ruling, were effectively silenced by it long before I ever spoke a word in Teesside." He gestured towards the packed benches behind him, where faces etched with worry and hope watched intently. "You accuse me of undermining the court. I suggest the greater danger lies in court decisions that appear divorced from the lived realities of the citizens they affect." He stepped forward slightly, closer to the bench. "You want to find me in contempt? You wish to potentially jail the Prime Minister?" His voice remained level, almost conversational, but the implications were staggering. "Then do so, my lord. Make history. Be the judge who sought to silence a Prime Minister for defending the very communities this government, this Parliament, was elected to uplift." He paused, letting the weight of the statement settle. "But understand this," he continued, his gaze sweeping across the courtroom, locking again with Thornton's. "When you hold me in contempt, you hold them in contempt too. The steel worker from Redcar, the mother from Ebw Vale, the fisherman from Grimsby. You declare that their concerns, their livelihoods, their hopes, are beneath the dignity of this court." For a long moment, Thornton said nothing, visibly struggling to contain his fury. The tension was thick enough to cut with a knife. The judge's hand trembled slightly as he reached towards the pre-prepared contempt papers lying before him. A court tipstaff moved almost imperceptibly closer to Starmer. The oxygen seemed to vanish from the room. History held its breath. Judge Thornton, his face a mask of cold fury, picked up his pen. With a decisive flick of the wrist, he signed the order. "Keir Starmer," he declared, his voice ringing with brittle authority, "I find you in contempt of this court." Gasps rippled through the gallery, quickly suppressed into a stunned silence. A sitting Prime Minister, found in criminal contempt for words spoken in defense of government policy. The constitutional implications were seismic, the political fallout incalculable. The tipstaff stepped forward. Keir Starmer didn't flinch. He calmly took off his watch, placing it carefully on the table before him. He didn't resist as the tipstaff approached, didn't offer any defiance beyond a quiet dignity. As the court official prepared to escort him from the courtroom, the symbolic, if not literal, act of arrest, Starmer raised his head, looking not at the judge, but out towards the gallery, towards the cameras broadcasting this unprecedented moment live. "I took an oath," he said, his voice clear and steady, resonating through the hushed room. "An oath to serve the people of the United Kingdom and uphold its constitution. That oath did not include bowing to judicial intimidation when defending the legitimate interests of the citizens I represent." He looked back towards the bench, his gaze unwavering. "You sought perhaps to shame me, my lord. I believe you have only succeeded in exposing the gulf between these hallowed halls and the realities faced by millions." He turned, and without a backward glance, allowed the tipstaff to escort him towards a side door leading to detention within the court complex. Outside the Royal Courts of Justice, as news filtered out, the quiet crowd erupted, not in anger, not in violence, but in a sudden rolling wave of applause, a sound of solidarity that echoed down the Strand, carrying the weight of history being made. The image of Keir Starmer being led away, calm and dignified, flashed across every screen in Britain within seconds. It wasn't the dramatic handcuffing seen in American dramas, but the quiet, procedural detention of a Prime Minister for contempt of court was arguably more shocking in the British context. By noon, it was the lead story globally. By early afternoon, spontaneous gatherings began outside the Royal Courts of Justice and Downing Street, swelling rapidly. The crowds were eclectic. Union members stood alongside small business owners, Labour voters next to disillusioned Conservatives from the red wall seats, united by a sense of outrage, not necessarily for Starmer the politician, but against what they perceived as judicial overreach, silencing a voice speaking for forgotten communities. In Middlesbrough, retired steelworkers unfurled a banner, "Thornton Jails Teesside's Hopes." In Merthyr Tydfil, a local choir sang traditional Welsh hymns on the town square. In Grimsby, trawler horns sounded in solidarity along the docks. The story transcended left and right. It became about fairness, about whose voice mattered. Inside Parliament, an emergency debate was demanded. The Attorney General issued a carefully worded statement expressing profound concern and confirming an immediate appeal was being lodged. The Lord Chief Justice was reported to be holding urgent consultations. Rishi Sunak, the Conservative leader of the opposition, condemned the unprecedented situation, calling for Starmer's immediate release while simultaneously criticising his initial inflammatory remarks. A careful political balancing act. But the public mood was less nuanced. A handwritten sign held aloft by an elderly woman outside the courts captured the feeling, "He spoke for us. Now we speak for him." The quiet dignity of Starmer's stand had unexpectedly ignited something powerful. While Starmer sat in quiet detention within the court complex, refusing offers of immediate appeal bail, "I will leave when the order is rescinded, not before," he told his lawyers. The pressure on Judge Thornton became immense. The Judicial Conduct Investigations Office was inundated with formal complaints. Senior legal figures privately expressed deep unease. Anonymous briefings, likely from government sources, highlighted Thornton's history of clashing with ministers and his perceived ideological leanings. Then came the leak that broke the dam. An internal court communication, obtained by The Guardian, surfaced online. It was an email from Thornton to a senior colleague sent 3 days before Starmer's hearing, discussing potential contempt sanctions. One line stood out starkly, If the PM wishes to play the man of the people against the judiciary, Thornton had written, perhaps a brief taste of custody will remind him of the proper order of things. The implication of premeditated punishment, of political motivation masquerading as judicial impartiality, was devastating. The leak transformed the narrative instantly. This wasn't about respecting the rule of law anymore. It looked like a politically motivated abuse of power by an unelected judge. The dam of judicial deference broke. Even newspapers traditionally respectful of the judiciary ran editorials questioning Thornton's conduct. A cross-party group of senior MPs tabled a motion calling for Thornton's immediate suspension, pending a full investigation. The pressure became unbearable. Late that evening, facing universal condemnation and likely intervention from the senior judiciary, Sir Reginald Thornton issued a terse two-sentence statement through his clerk. Upon further reflection, the finding of contempt against the Prime Minister is hereby vacated. No further comment will be made. There was no apology, no explanation. But it didn't matter. The order was withdrawn. The next morning, Keir Starmer walked out of the Royal Courts of Justice not as a man chastened, but as a leader transformed in the public eye. He didn't pump his fist, didn't deliver a triumphant speech. He simply stopped before the waiting bank of microphones, looking tired but resolute. "I thank the court for its decision," he stated calmly. "I was never in contempt of the law, only in contempt of the idea that justice should be blind to the needs of ordinary people." He paused, his gaze steady. "I was never alone during my brief detention. Every citizen of this country who feels overlooked, ignored, or punished for speaking truth to power stood there with me." He looked directly into the cameras. Perhaps now, he concluded, before turning and walking towards his waiting car, we can focus less on silencing dissent and more on addressing the real challenges facing the communities I was elected to serve. The crowd erupted in sustained applause. In that moment, Starmer, often perceived as cautious, loyally, even slightly dull, had become an unlikely symbol of defiance against establishment overreach. A champion, however briefly, for the very forgotten communities his government was struggling to convince. His approval ratings saw their first significant jump in over a year. The failed attempt to jail him had, paradoxically, made him a national hero, at least for a time. The political landscape shifted dramatically in the weeks following the courtroom drama. The Starmer surge, as commentators dubbed it, was real, albeit potentially temporary. Labour's poll numbers improved, closing the gap with the Conservatives. More significantly, Starmer's personal ratings climbed, with focus groups highlighting newfound respect for his perceived strength and willingness to stand up for ordinary people. The government seized the momentum. The previously stalled Levelling Up Fund Enhancement Bill, containing the disputed Teesside grant, was reintroduced and passed swiftly with cross-party support, presented now as a matter of national fairness. Simultaneously, the backlash against the judiciary, particularly Judge Thornton, led to tangible reform. A bipartisan parliamentary committee, fast-tracked in response to public outrage, introduced the Judicial Accountability and Transparency Act. While respecting judicial independence, the Act established clearer guidelines on contempt proceedings involving ministers, strengthened the independent complaints process, and mandated greater transparency regarding potential conflicts of interest for senior judges. It passed both houses with overwhelming majorities within months. Sir Reginald Thornton, facing investigation by the Judicial Conduct Investigations Office and universal condemnation, opted for early retirement, his career ending in disgrace. His name became a byword for judicial arrogance. Keir Starmer, however, deliberately avoided triumphalism. He rarely mentioned the incident directly in subsequent speeches, focusing instead on the policy issues he had championed all along. While Westminster debated the long-term implications, Starmer made a point of returning quietly, not just to Teesside, but to other communities often overlooked by the London-centric media. Former mining villages in Nottinghamshire, coastal towns in Cornwall, struggling agricultural areas in Lincolnshire. There were no grand rallies, no major policy announcements, often minimal press coverage arranged by Number 10. He held town halls in community centres, visited local businesses, met with union representatives and community leaders. He didn't arrive with promises. Mostly, he listened. He heard firsthand the frustrations about lack of investment, crumbling infrastructure, the feeling of being left behind. He acknowledged the challenges, spoke about the Teesside funding as a small step, but emphasized the long road ahead. He didn't shy away from difficult questions about the economy or migration, offering sober assessments rather than easy answers. What struck many local reporters and attendees was his quiet intensity, his focus on detail, a marked contrast to the sometimes detached persona seen in Parliament. It wasn't about fiery speeches, it was about presence, about acknowledging realities often ignored in national discourse. One local councillor in a former Derbyshire pit village remarked afterwards, "He didn't promise us miracles." But for the first time in a long time, it felt like someone from Westminster was actually listening, properly listening. This quiet rebuilding of trust, far from the headlines, felt more significant to Starmer than any temporary poll bounce. Months later, the initial surge of public support inevitably receded as the daily grind of governing, economic challenges, and new political controversies took over. Keir Starmer remained Prime Minister, his authority bolstered but still facing immense hurdles. The memory of the courtroom confrontation, however, lingered in the public consciousness, a strange footnote in political history. It hadn't solved the UK's deep divisions, nor had it magically transformed Starmer's long-term political fortunes. But it had offered a fleeting moment of unexpected unity, a reminder that standing on principle, even against overwhelming institutional power, could still resonate deeply. It also served as a cautionary tale about the delicate balance between judicial independence and democratic accountability. One evening, sitting quietly in the study at number 10, reviewing briefing papers, Starmer paused. He looked out at the lights of London, thinking back to that packed courtroom, the faces in the gallery, the weight of the moment. He hadn't sought the confrontation, hadn't planned the outcome, it had been thrust upon him. Yet in refusing to back down, in choosing to stand with the communities he represented, he had inadvertently tapped into something powerful. He still didn't have all the answers. The challenges remained immense. But the memory of that day, the quiet dignity against the perceived arrogance of power, served as a constant grounding reminder of why he was there. The fight for those forgotten communities, he knew, was far from over. It was perhaps just beginning.